Hi, Peter. Today, I want to pick your brain a little bit about evictions under Alert Level 4. So, last night in the media briefing, it was very clear when the minister spoke there are no evictions that need to take place at the moment. And yet, when we look at the actual regulations that have been published, there is specific inclusion around evictions.
Michelle, it's actually quite interesting. When we had a look at the draft regulations about a week or so ago, after the initial speech regarding the lockdown level 4, we called it a lockdown level 4, the different levels that we had at this point in time, there was nothing actually mentioned regarding evictions in South Africa. And when we saw the regulations actually being passed last night, the gazetted regulations, there was actually quite a lot regarding evictions and moving of people from certain areas to other areas. So let's have a quick look at what the final regulations say from last evening. Prohibition of evictions. Specifically, Section 19 says, a competent court may grant an order for the eviction of any person from land or a home in terms of the provision of Extension of Security of Tenure Act, that's ESTA, and the Prevention of Illegal Eviction and Unlawful Occupation of Land Act, we call that PI, provided that any order of eviction shall be stayed and suspended until the last day of Alert Level 4, unless a court decides that it is not just and equitable to stay and suspend the order until the last day of Alert Level 4. So it's actually quite clear what we've got in the regulations at the moment, that the courts are allowed to hear eviction matters, they're allowed to grant eviction matters, but the execution of that actual eviction matter, the eviction case that was heard, can only occur after level 4 has ended, so possibly in level 3.
So, Peter, practically speaking, I mean, landlords at the moment or previously landlords were in a very difficult position because tenants who were not paying, there was no real recourse for landlords to encourage their tenants to pay. Now it would appear that there is actual recourse for the landlord.
100%, Michelle. So normal process still needs to be followed. So a letter of demand still needs to be sent. The lease still needs to be cancelled in terms of the Rental Housing Act, the Consumer Protection Act, or your commercial lease agreement. However, you can start following normal procedure when it comes to eviction, like contacting the attorney, having them open up a file, having them actually approach the court at this point in time for the eviction order to be granted. It's just the execution that is stayed at this point in time, not the actual hearing of the matter.
So the process leading up to the eviction then, Peter, the letter of demand. Chat to me about the letter of demand and service and how that needs to be sent.
Well, Michelle, let's have a look. Let's split the two between commercial and residential lease agreements, if you don't mind. Let's do that at this point in time. Even though the regulations don't make a differentiation between the two types, you're obviously dealing with two different pieces of legislation, whether it comes to the Rental Housing Act, whether it comes to the Consumer Protection Act. So normal process of collection would be as follows. If a tenant does not pay rent on or before the 1st, like what we usually go on about, a landlord or the estate agency or the managing agent would be able to send a letter of demand through to the tenant, asking them or demanding of them to make payment of the amount outstanding within a set period of time. Usually that set period of time is a 7 calendar day or a 20 business day time period in terms of the Consumer Protection Act. So that letter of demand must be delivered. It depends on your lease agreement how that letter must be delivered. But currently, for your purposes, sending out letters of demand by email is absolutely perfect. You can still go and do that. But that letter of demand must go out. So the normal collection procedure must occur prior to you cancelling the lease agreement and being in a position to be able to approach an attorney for a eviction application to be processed.
And 20 business days? The 20 business days have been cancelled in terms of the National Credit Act. What about the Consumer Protection Act?
Interesting question, Michelle. So in terms of the National Credit Act, you've actually only got two processes that this affects. So in terms of the National Credit Act, just once again to reiterate, the business days have been completely stayed in terms of the NCA. So that means even if you send out a letter of demand for NCA purposes, And those purposes are specifically only related to things like blacklisting a tenant and following normal NCA application processes to collect rent. But for Consumer Protection Act processes, the 20 business days is still counted. So the business days are still business days in terms of the CPA. So if you do send out a letter of demand, say, for example, on today, we all know that if there's a public holiday tomorrow, Friday, Saturday, Sunday, your first business day will be counted on Monday next week. So those business days are still counted. It's merely for National Credit Act purposes that the business days are stayed, not for CPA, not for Rental Housing Act purposes. So those letters of demand still count. They can still be sent out. The days can still be counted when it comes to cancellation of the lease agreement or following other collection procedures that are not indicated in the National Credit Act.
Peter, eviction would be a last port of call in reality. What we really would recommend to tenants and landlords is to communicate and negotiate at this point in time. There have been many tenants that have legitimately lost income and legitimately cannot move because the regulations prohibit them from actually vacating the property. And so they're stuck in the property with no income. What other alternatives in terms of negotiation would the tenant and landlord have?
Michelle, I think the important thing here is also, just like what you've said, is effective communication between a landlord and tenant and agent is vitally important during this time period. TPN has made documents available called a deposit utilization agreement, as well as a rental deferment agreement as part of our rental recovery pack. It's all available from the TPN shop. If you need assistance with those documents, you're more than welcome to contact the legal eagles at TPN. They'll be able to talk you through the actual agreements and how they work. But basically, what you can go and do from a landlord or tenant's perspective or an agent's perspective is negotiate regarding a rental deferment. So perhaps a stay or a proportionate stay in payments of rentals. Say, for example, a 50% stay in payment of the actual rental amount for a certain period. The tenant needs to catch up on those payments later on, depending on how you filled out the documents. And obviously, the deposit utilization agreement is also part of that pack. And that allows the landlord and tenant to agree to utilize the deposit for a rental amount for 2 months rental. It depends how much deposit you're actually keeping of the tenant. And that can be negotiated around with the landlord and the tenant. But just like you said, effective communication between the parties is incredibly important. So for all the tenants out there, for all the landlords out there, make sure you're communicating between the parties so that you know what financial position each party is in, what people can afford during this time period, and make sure you are documenting the actual agreement between the parties and using those agreements to your benefit, to everybody's benefit. At the end of the day, those documents don't just help the landlord, they help both landlord and tenant.
Peter, these are very difficult circumstances. They're very, very difficult times and uncertain times. Right now, we've only got lockdown alert level 4. We still don't know what 3, 2, and 1 look like. We still don't know when property practitioners will be able to hit the road, start with their viewings, start with their inspections. I guess we're just going to have to wait for the next regulations to be published.
100%, Michelle. I think from a legal and a TPN perspective, we always hate saying we don't know, or we can't give you a direct or a clarified answer on something. We can give you answers regarding level 4 and what level 4 means for the industry, for the property industry as a whole, but we can't speak to level 3, we can't speak to level 2, we can't speak to level 1, because we actually don't know what those final regulations, what that's actually going to contain for the market itself. So unfortunately, at this point in time, just like what you said, we're all a little bit in the dark of what's busy happening with regards to other levels, but level 4, we've got a very good indication of what can occur and what can't occur during level 4, the level 4 actual lockdown. Yeah.
Brilliant, Peter. Thanks very much for your time. Folks, thanks for joining. Thanks for listening in. Remember, you can contact TPN's legal via email legal@tpn.co.za. Reach out to us on 0861 876 000 and access the recovery documents by clicking on the link below. Thank you very much.
Thanks, Michelle.